Okay, I'd like to call the meeting to order and acknowledge that we are in Treaty 1 territory, the home and traditional lands of the Anishinaabe, Ojibwe, Innu, Cree, and Dakota peoples, and in the national homeland of the Red River Métis. Our drinking water comes from Shoal Lake 40 First Nation in Treaty 3 territory. My name is Neil Harden. I am chairing today's panel. With me in the room is Gail Anderson, and via Zoom is Doug Marks. The assessor today is Stephen Lobenstein, and the recording secretary is Belen Rojo. To the Zoom participants of the hearing, please note you are placed in the waiting room until your property is called upon. When it is your turn, you will be admitted into the meeting. Kindly follow along on the City of Winnipeg's Board of Revision YouTube channel for the hearing process. Once the host admits you into the hearing, please close or mute your YouTube player. You will then be permitted to speak with respect to your property. Once your hearing has concluded, you can leave the meeting. We will be hearing applications for revision of the assessment rule in accordance with the Municipal Assessment Act. The matters for which revision is requested have been described in each application and will limit discussion to those matters. The statements that are made at this hearing are sworn testimony, and anyone speaking to the matters must be sworn in. Be advised that comparisons of assessments of properties are not considered evidence of market value by the board. The board is appointed annually by council and is independent of it in the city administration. It makes its decisions on the basis of the evidence provided at this hearing and issues a written order to be mailed to all parties as soon as possible. Please note that the board's decisions with respect to an application may be appealed to the Manitoba Municipal Board if the matter pertains to assessed value reclassification, or to the Court of King's Bench if the matter pertains to the application of exemptions from taxation. Should you wish to appeal, information on how to do so will be included with the board's order. With respect to the hearing process, I will confirm the point of appeal with your property to be addressed with each applicant following the swearing in. We will then have the assessor's testimony followed by questions the applicant may have, and then the applicant's testimony followed by questions. Each side will have an opportunity to summarize if they wish. Once all the evidence about an application has been brought forward, the applicant may leave. The process will repeat for each item on the docket today. This session will close after all the applications have been heard, and the board will deliberate in private and make its decisions. You will receive the board's decision by registered mail as soon as possible. As information, all public hearings are live streamed, recorded, and will be part of the public record. We will be hearing items 4 through 9 on our docket today. Ms. Rojo, please affirm the assessors and applicants' testimony for the first property.
Mr. Assessor, please state your full name.
Stephen Lobenstein.
And you affirm the evidence you're about to present is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Applicant, please state your full name.
Marky Neufeld.
And you affirm the evidence you're about to present is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay, the first property we will be hearing today, docket number 4, 2050 Main Street. So, Mr. Lobenstein, you can proceed.
Sure.
Sorry, we have a preliminary matter.
Okay, what is that?
I don't have any evidence from the assessor.
The evidence was exchanged yesterday when we received yours.
I don't have it in my records, never received it.
Okay. Belen, do you know when it was provided by the city to
Yeah,
the assessor?
I'm checking right now. It was submitted yesterday afternoon at 3:30.
The city's
No, the evidence was exchanged upon receipt of the applicant's briefs yesterday afternoon at 3:30.
Okay. So the applicant received it at the time that he brought his brief in then.
Correct.
That is their position. That is not correct. I have the email in front of me and it says I will send it. There's nothing attached.
Okay, I'm sending it to you right now, what I had submitted yesterday afternoon.
Who would that have come from? Well, yourself, Ellen, or was that from?
No, it came from me.
Okay, I got the last email I had from you was actually the link for this hearing, and then I'm looking in the appeals file which we maintain, and nothing from you for quite some time here.
I just resent my communication from yesterday.
What was the size of the file?
6 megabytes.
Belen, just on an aside, the applicant's brief labeled item 4, 2050 Main Street,
Yes.
it actually contains the information for 121 Gomez.
I may have mislabeled them. I'll look.
Oh, you know, it's the heading is 121 Gomez. The body is 2050 Main.
Oh, so that's item 5 then there.
Yeah, they never changed the heading on it.
Yeah, it's the right content.
Okay, because I'm pretty sure I used his label.
It is the right content. Just the heading is incorrect.
Oh, the heading is incorrect. Okay, I see.
Now I'll send you my last communication. This is what.
Did you get the one I just sent now?
No.
It's not sitting in my outbox anymore.
Well, this is the last communication we have, and I just send it back to you. This is Bram's submission, and the last statement we had was, "I will forward the assessor's brief shortly," and that was at 3:30.
Yeah, and then right after that, I drafted the email for the exchange because we have a template for exchange.
Yeah, I see.
And
Okay, I'm just looking. Okay, now I'll check the appeals file. No, nothing there. Mr. Chairman, just so I'll give you a bit of background on this while we're waiting for the electronic mails to transfer, is that there was a issue relating to the original notification from the Board of Revision. And I've discussed this with the appeals manager, and there were some issues. In any event, we never filed our material on the day that it was required. And what we then asked for was, can we get the assessor's brief? Because regardless of what happened on the filing, regardless of who's to blame, many times you can handle these appeals in rebuttal, and the owner then gets a fair hearing. So on the 17th, we contacted the assessor and asked for a copy of his briefs, and he refused and directed us to the Board of Revision. The Board of Revision never got around to addressing this matter until yesterday around 12:30 p.m. And there was a second case that was scheduled for yesterday at 1 o'clock, and the two matters were related in terms of the service issues. So then I saw Bellin's email, and sent at 3:30 to Bram and saying it was coming, and that's the last I heard of it. Now I now see that Bellin has sent me what she sent at 3:33, and this was sent to Bram, not me. Minor point, but of course I am the name on the application form, and we did provide a different email address that we use for these so we can track them properly. So regardless of the series of events, as of right now, this would be the first time I've seen these. And we had the same issue yesterday. And so, no opportunity to review, no opportunity to rebut. Yesterday, the board met and did get some advice, it appears, from the appeals manager, and decided that for fairness, it should be adjourned until such time as we can review. And what they did was open the hearing so that in essence the hearing had started, and therefore it closes off the opportunity for new evidence, and that we did not object to that. And then allow enough time for a proper rebuttal and to be held at a later date. And we just want the same thing now. And I appreciate that it was sent to us, but even if it was sent to the wrong person at 3:30 yesterday evening, it's just not appropriate either. It's 9 o'clock in the morning, 3:30 at night. I don't think that's fair. So that's what my request would be, is to follow what happened yesterday. Same sequence of events, and open the hearing and request an adjournment.
Okay, when did you provide your brief?
We never provided information in general, and that was a different matter altogether. This is a series of events. We did provide a rebuttal briefs just so we had something on file. We were completely guessing. We didn't know what we were rebutting, and that was 3:30 yesterday.
Okay, but your main brief, you didn't provide a main brief?
No, we did not.
Okay. All right, Mr. Lobenstein, do you?
Yeah, I have a few things to say. I want to note my objection to Mr. Neufeld for sending in the evidence at 3:30 yesterday. That's quite late, of course. On top of that, I'm not too sure how he can rebut anything when no evidence was submitted. He did not receive my evidence until he sent his in, so I'm confused on how anything could be rebutted.
Well, that's precisely my point. I was deprived of the opportunity to rebut. I have that right to do it, and I was deprived of the right. We rebutted in blindly.
Well, no, you weren't deprived. You didn't submit your evidence.
No, yes, we were deprived. You're talking about a council policy that is based on an interpretation of one person. We're not talking about the concept of natural justice or what transpires in the courts of our land, where if there is a burden of proof on the assessor, that the appellant always gets the opportunity to review the evidence regardless of anybody's policies. It's just not fair.
Okay, Mr. Lobenstein, did you submit your brief, your main brief in with regard to the timeline?
I did.
You did, okay. And Mr. Neufeld, did you submit your brief, your main brief? With regard to the timelines required?
No.
Okay. And Belen, do you know what is the procedure, the administrative procedure? Do you send a city brief at the time it's received from the city, or do you wait till you receive the appellant's brief?
We've been instructed because of the digital exchange to only exchange when we have briefs from both parties. We do not release documents when we've only received it from one party.
Okay.
So which party does not file.
All right. There any questions from the panel to either the applicant or the assessor on the issue? Gail, do you have any questions?
No, I have no questions.
Doug, do you have any questions on the issue?
Not at this time, thank you.
Okay, then I guess we're going to have to go in camera and discuss the objections to this, and then we'll get back when we've made a decision on this.
There is just one issue to the other issue I wanted to bring up, and there is case law on this matter. My legal counsel is in a hearing on another matter, so he was unable to attend. And I am just citing that the case law of IKEA versus the city of Winnipeg be considered as well, in which a similar style occurred where no notice was given. And in that case, the courts ordered a new hearing.
You supplied that case law?
Sure.
Yeah, if you're going to cite case law, please give us.
Oh, yeah,
case
sorry.
law.
I don't like citing case law. That's not my walking outside my but I'll send it anyway.
Devil's in the detail on case law.
Yeah, that's true. The other case law I can cite was yesterday, and it's again it was related to exactly the same set of incidents. And yesterday, the board determined that for fairness, that we had the opportunity to at least review the matter and provided a rebuttal as we were deprived of our rights. And in that case, it was 40 minutes notice before the hearing. In this case, we can call it 1 hour before the hearing, considering the time it was delivered at night and working hours. And I'm just going to send this to directly to Belen. And lastly, again, this is argument. The concept of policy is the board's policy is in conduct of a hearing. That does not excuse anybody of the responsibility to comply with the act and address the burden of proof. the goal of the act and all legislation is to act reasonably. And if a filing deadline is missed and the parties need the right to review it and respond, we already lost the right to supply evidence in chief. And we're not going to argue that issue because as we all well know, if you have the opportunity for rebuttal, you do stand the chance of providing a fair response to the city. But if we're deprived of that response because it's sent to us a few minutes before the hearing, that's not a fair enough time. And what Bellin said was that is their policy. What is also their policy is to attempt to effect an exchange a day or two in advance, so the parties at least have the opportunity to respond. That wasn't mentioned, but that is the case. And the next issue is that the assessor should respond because there's nothing stopping him from doing it. And we run into this situation a lot with assessors and with ourselves. And the assessor calls me and says, "Hey, I'm going to be late." I said, "Fine, that's okay. You want to, you're going to do rebuttal? Fine, that's okay." Because nobody's trying to use a procedure to their advantage, or people should not be attempting to use a procedure to their advantage. It's about fairness. So I found the actions of the assessor to be improper. He was contacted 2 days ago and decided to hide behind the board's policies, not the law, their policies. He has his own policy.
Mr. Newfield, I won't entertain any blame on the assessor. He provided his brief when he should. It was you that didn't provide the brief. And administrative.
We're not talking about the brief. That's done.
Please don't interrupt me. And two, principle is that a party cannot seek to make a case in rebuttal that should be made in evidence in chief. So,
not trying to make a case. It's the burden of proof. I get to challenge the burden of proof, and I can do that effectively in rebuttal if I have the data in front of me to look at.
Well, we'll get around to that. Mr. Levinson, do you have anything you wish to respond to?
There are policies to follow. I follow them correctly. So that's all I have to say.
Okay.
Just again, I have objections to him submitting late evidence. That's all.
All right, Bedlin, do you have the case law cited by Mr. Newfield as yet?
Yeah, it should be in everyone's folders, and I've emailed that to the assessor as well.
Okay.
I haven't received it yet.
Because I sent it to the wrong Stephen. Sorry, 1 second.
I have it. Thank you.
Okay, you should have that now. I'm sorry.
What is that under, Bellin?
I labeled it under item 4. It'll say applicant case law.
Yeah, I received it now. Thank you.
Okay. Let's give you, Mr. Levinson, a few minutes to skim the case law and then provide any response to that if you so wish.
While he's checking that, I'm wondering, does the original application to the Board of Revision, does that form part of the case file?
Don't understand your question, sorry.
Well, the form that was filed on this appeal,
Yes,
can that be also provided to the parties?
Oh, you want me to share that? Okay, yeah, I'll put that in. Hey, the application is uploaded to the folders as well. Stephen, I believe you should already have a copy of that.
Sorry, I was reading. What was that? A copy of?
The application for the files on this docket.
I do have an application. I believe we all got applications for this and a notice of hearing.
Okay, thank you.
So my understanding is this is just from, this case law is from somebody not appearing at the hearing. Not being contacted as to why.
No, it was a case of notice sent to the wrong party.
Okay, so it doesn't really relate to today because you received the notices.
No, I told you that the initial issue had to do with the fact that there was a miscue on the delivery of the notices to us in whenever they came in September.
Okay, well, I'm not sure about that, but he's supplied his information, so I guess it's up to the board to decide what they want to do.
Okay,
And does the board have the copy of the transmission of the evidence that they referred to yesterday? I'm looking at it now. Or do you need? I believe Ellen just sent it to me, and I'm wondering if that was shared with the board as well.
If I shared my email with the board,
Yes, the one that I received from you a few minutes ago of the original transmission
of the evidence exchange.
that was sent to Bram yesterday at 3:33.
Okay. In that case, I will also share your submission.
I've just sent a screenshot back to you, just so you know what I'm talking about.
I've received it.
So you're saying no notice was sent to you for this hearing? You didn't get an application, Rocky?
No, we didn't get the appeal notices in the time frame required, and that's what started this whole issue of us missing the deadline. And we're not coming to this board to make an issue of that. We had come to agreement with the board and said, look, we can deal with this. We don't think have a major disadvantage if we were allowed proper rebuttal. And yesterday, the data came to us at 40 minutes before the hearing, and they felt that that was not adequate time for a proper rebuttal. Today, you see in front of you that the evidence was sent to Bram at 3:33 last night, but you'll also note in the application form that it's my name on the application form, and there is a different address for service indicated. So I did not receive it until 9:30. 9:16 this morning.
Sorry, my computer froze.
So I'm not asking for anything irregular. I just, if we had 5 days to even look at this is all we really need and reasonably respond to it for fairness.
Now, I understand that, but isn't fairness both of us exchanging our materials at the same time? In essence, now you have my material.
Yeah, but I can't submit new material. I've lost the opportunity, not you. I've been disadvantaged because I can't submit new evidence. And your material, because there's a law on the burden of proof, is essentially by the law, meaning it should be available at all times because you have to be able to prove it. So this isn't a question of me looking at yours and formulating a response. This is, you're required to do that in the first place by the Act. And I can even tell you what I'm going to respond on. I'm going to talk about the fact that the contamination issues on these properties, and I'm going to talk about the comps. And I'm allowed to do that. There's not going to be any secrets here.
Okay, is there anything else that either party wishes to bring to our attention?
Not at this time.
No, thanks.
Okay, I think then we will go into recess for the board to consider the matter. Okay, good morning. Rocky and Steve, are you there?
Yeah, over here.
Yes.
Okay. The board has considered the presentation to both parties, and we will adjourn 250 Main Street, 121 Gomez, and 2141 Logan until October 28th at 9 a.m. in Boardroom A. So that's Friday, October 28th, 9 a.m. in Boardroom A. So at this point, then we will proceed on to 487 Fernbank Avenue.
But before I depart, just to confirm that what we're doing here is adjourning, so there is no new evidence allowed, only rebuttal. Is that,
No new evidence. That's a
Correct,
good question.
because evidence exchanged has already occurred.
Right, and we have already agreed with the board that issue is dead. It's all we wanted to ensure is that we could properly provide rebuttal, and I'm expecting to get a very harsh review of my rebuttal to make sure I stay in a straight and narrow.
Yes, rebuttal is always allowed.
Thank you. Thank you, boss.
Okay, well, we get Mr. Slaughter in. Maybe we'll just have a quick 5-minute break.
Okay.
Thank you.
All right, good morning. We'll resume and we will go on to 487 Fernbank Avenue. Oh, Belen, can you swear in the new applicant?
Mr. Applicant, please state your full name.
Rod Slaughter.
And you affirm the evidence about to present is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
All right. So on 487 Fernbank, Mr. Lobenstein, you can proceed.
Sure. The roll number is 0500-390-5500-487 Fernbank Avenue. The assessed value is $752,000. I do have a verbal recommendation for $250,000. That's $250,000 for a recommendation.
Okay, and how did you arrive at that figure?
That'd be about $1.76 a square foot. That's
So
just
the lowered rate.
yeah.
I'm sorry, I was unable to hear that.
I lowered the land rate to $1.76 a square foot.
Thank you.
Okay, and Mr. Slaughter, how do you feel about that number?
We haven't received official confirmation from our client, but we accept on their behalf, Mr. Chairman.
All right. Any questions from the panel on that number or on this property? Okay, hearing none. We will move on to 645 Washington.
Okay, the roll number is 0204062020 645 Washington Avenue. The assessed value is $430,000. Again, I have a recommendation for this one at $378,000. Again, that's reducing the land value, and that recommendation is $378,000.
Okay, again, Mr. Slaughter, how do you feel about that value?
We'll accept on behalf of our client. Thank you, Mr. Chairman.
All right. Is it going so much smoother? 1495 Brookside. Let me just open that file. Okay, 1495 Brookside. Mr. Lobman.
Yep, the roll number is 13095406000, 1495 Brookside Boulevard. The assessed value is $564,000. Again, I have a verbal recommendation for $439,000, and that's a reduction in the land rate. So that's $439,000.
Okay, Mr. Slaughter, how do you feel about this value?
We accept on behalf of the client, Mr. Chairman. Thank you.
All right, any questions from the panel?
None for me.
None for me.
Okay, thank you. And my apologies to the panel for not asking for questions for the last property. So if you have questions on the last property, now's the time. Okay, so I guess that brings us to the conclusion of today's hearing. We have heard all the items scheduled and this hearing is now adjourned. So thank you very much.
Thank you.
Thank you. Thanks, Stephen.
Thanks.